Good morning, everybody. Hope you're all well. We're going to get started now. It's about 5 minutes past 11, and I know we only have till 12:30. And I know that this will be videotaped, so it will go to a larger audience. But right now, I think we have a manageable group of people on. If you'd like to introduce yourself with your name and maybe the industry that your company is in, if we can get that information, it would actually help us to tailor some of the material we kind of covered today, and maybe it'll be more applicable to you. So my suggestion is just to give ourselves maybe a couple of minutes to see if anyone would like to unmute and just volunteer their name and their industry.
Or you can put it on the chat.
Or feel free to, yeah, exactly. Put it on the chat and we can mention it.
Yeah. Okay. Let's start with the introduction as things are put on there.
So my name is Arjun Aluwalia. I'm a co-founder of Argentum Law. We essentially are a law firm that focuses on general counsel services for companies all the way from early stage ventures all the way up to large conglomerates. We operate globally in the US, Canada, the UK, and here in the UAE. My own background is I'm mostly in technology and M&A lawyer, doing a lot of corporate work. And I'm happy to introduce my co-founder, Usman Abu Bakr, as well.
Hi. My background is oil and gas, construction, and general commercial matters, distribution, agency, franchising. I've been a career general counsel. Really started as a GC. Can't remember now. Feels like a very long time ago. So really kind of understand the issues that can plague an executive in a multinational startup, medium-sized businesses. And haven't we all been tested in the last 3 months? It's been a roller coaster ride. Yeah.
So we have Iman who is representing the transportation industry. She has I guess she comes from a technology background for her company. And as the names and backgrounds come in, we'll drop it into the chat. So we'll start off with just kind of giving you a lay of the land and how we'll cover this. We'll start off with an introduction. We'll set the scene to talk about what has happened over the last 3 to 4 months. And then we'll address the themes and the issues that we've dealt with during the crisis. We'll talk about some of the real life case studies that have been faced by businesses that we've been representing, big and small. And all this to the end, which is the ultimate goal of this presentation, is really to arm you and empower you with lessons learned, things that you can actually practically implement in your businesses. The lessons learned from this crisis, which are largely unprecedented, right? This crisis was completely unexpected in its gravity, in its scope, in its breadth. No industry is untouched, and so you're talking about what might be sort of a once in a lifetime event, which, when you think about it, if you can come through this very, difficult moment, it presents an opportunity for businesses. It presents an opportunity to regroup, restructure, reassess, look at, how to strengthen their contracts, their underlying infrastructure, and, sort of protect themselves better from liabilities in the future, and also take advantage of opportunities better in the future. So with that being said, the whole point is, not to be, pessimistic about this, but rather to be optimistic, because this crisis presents an opportunity to be a better business after the crisis has hit. And so with that being said, we'll just touch upon setting the scene before we kind of go into back and forth. Also, if you do have any questions, feel free to post them up into the chat, and we'll address them as we go along. Or we can also, we'll try to finish up our part here rather early so we can at least have some Q&A on the chat. And also just, feel free to chime in towards the end. In terms of setting the scene, obviously the COVID crisis has led to a number of features, right? You have dramatic revenue reductions. You have a situation especially true for startups, where fundraising has become way more selective and more difficult to go through. You have supply chains that have been disrupted. In the real estate context, you have commercial leases that that are basically interrupted in the sense that you're not able to operate out of your locations anymore for any number of reasons, including government rules. And the point being that a lot of the commercial landlords may have not been amenable during the crisis. And the other part of it also is that you end up having these business interruption issues, which even if you're insured, many of the insurers have been giving our clients some trouble. So all this to say that this crisis has hit every industry pretty much that we represent.
Yeah, it goes without saying that the unique thing this time is that everyone had to stay home.
That's right.
That's shocking. Where the economy is built on people being out and about, going to offices, moving around the world. The world's becoming globalized, and people can move around quickly. Supply chains, money transfers, everything's just in time. Everything's just accessible, and suddenly everyone's stuck at home, isolated.
Yeah.
Businesses fragmented. People working from home. Communication issues and so on, with the government stepping in and saying you cannot be in contact with others. So it really an unbelievable disruption to the concepts that were the foundation of doing business.
Yeah.
Especially in this region where a lot is built on face-to-face, business, trust being built and doing business face-to-face. It's all gone.
Yeah.
In a matter of weeks. It's just how quickly this developed.
Yeah, absolutely. And given what we've gone through in the last 3 to 4 months in your practice, what would you say are some of the lessons that you've sort of learned from kind of going through the last 3 or 4 months?
The biggest thing, if I think of that one area that of a contract or of doing business that myself and clients have been exposed to the most are around the contractual clause of force majeure, where you had problems with leases, with client payments, disruption in supply chain, and the reasons being given for not performing these things been hung on the concepts of force majeure. And it's very interesting that because things happen so quickly, what's happening is that businesses have just sent notices that say COVID-19, pandemic, government measures, and therefore I'm entitled to stop paying, or I'm entitled to stop performing, and skipping the step of actually making the argument that COVID-19 or the government precautionary measures actually impacted the performance of the contract. And been on both sides of the use of that legal concept. And really what's missing out there was understanding that the force majeure concept actually comes from either the drafting in the contract, the contractual clause. It's called force majeure. It tells you how to use the force majeure and when you can use the force majeure excuse. Or in some jurisdictions in the world, like here in the UAE, there's the civil code where the law's codified, and they have a provision in there that describes what is a force majeure, how to use it, and when to use it. And the biggest lesson learned is don't just accept that when somebody tells you that they can't perform the contract, that they can't pay because of force majeure, it's not a foregone conclusion that they're correct. So check the law, check the contract, because maybe they don't have a leg to stand on saying that force majeure is affecting them. That's number one. Number two is, now that we know that a pandemic like this can cause disruptions in performance, hardships in performance, make sure that you have a contractual clause that covers this type of thing. A shutdown of the economy, you need to make sure that it's reflected in the contract.
Yeah. And just to, for our audience, you have, of course, in every, contractual setting, you have the contract, which will set out, the contract, the terms that are going to guide the relationship between the parties. Because remember, every contract is a risk allocation between the two parties. What you're putting out into the contract is essentially, allocating risks either on the other side, or you're allocating risks to yourself. And so what you're trying to do in every contract negotiation is allocating the risk to the appropriate sort of commercial understanding of what you can do, what you can't do, what you expect the other side to take responsibility for, and what you're going to take responsibility for, right? Mm-hmm. And so the risk allocation that you set out in your contract, part of that is, of course, the force majeure provision, which is really about unforeseen events.
Yeah.
And what Usman has kind of touched upon is that, there are two levels of inquiry when a startup comes in and basically asks a question around touching on force majeure. There is the contractual basis, what you have agreed in the contractual discussions. Mm-hmm. And frankly, almost every single time, and this isn't, something you don't just see with startups, the contracts that startups enter into. You see it even with big companies. Very little attention is paid to the force majeure clause at the back of the contract. You tend to see a lot of companies, and it doesn't matter if you're big or you're small, but they end up taking template contracts that are inappropriate for their type of sector. Mm-hmm. They haven't fully thought through the allocation of risk for their particular industry, or that's market standard for them, or even appropriate for their kind of type of company, right? And so they're not fully thinking through all this legal boilerplate at the end, which is usually drafted very badly, because most contracts, frankly, are drafted very quickly. They're
in the middle of the night.
Exactly, and a lot of times they use templates which are just inappropriate, like, using, for example, we've seen this, using a lot of American-style contracts, which use a lot of legalese. And I'm an American lawyer, and I'll be the first to admit that a lot of American contracts have extraordinary amounts of legalese that are very difficult to understand. Yeah. And, clients end up using those template contracts, and then when a stressed situation happens like COVID, and you actually have to test those provisions, you realize they're completely inappropriate for that company. And so, that being said, there is the contractual basis when you have a force majeure event, as Usman touched upon. And then there's the statutory basis, which Usman just touched upon as well, which is the idea that there is always a background legislation of the country that you're in. And in our case, in the UAE, there are provisions that may apply and may protect and may be able to give you leverage that exist in the statutory law of the country. Yeah. And so, Usman, what would be the typical? So a startup or a company comes to you and says, listen, I have this contract. I have to, basically build out these widgets and provide them to company X. I actually don't want to. It's just uneconomical for me to get the factory running and get get these widgets made. What kind of inquiry are you making? What are the steps that you take with the company, mm-hmm. to assess what they should do.
You mean in the face of possible force majeure?
Yeah. So the company may claim that I'd like to use force majeure as an excuse not to perform my obligations. Could you just walk us through, like, what the steps you would take as a lawyer?
Yeah, the first step is to take a look at the force majeure clause, and see whether whatever the event, this global event or this regional event that is occurring at the time, understand how it impacts the performance of the contract. If you can draw causation between that event and the performance, then you can argue that it's related. You also have to argue that it's unforeseeable. Most force majeure clauses will state that if you are in a position to foresee this event occurring, then you have to take the necessary precautions. In terms of when you're entering into a contract, and making sure that you are covered in regards to a force majeure, it's very important that you go through, read, and make sure that if you are dealing with a supplier, that you enumerate, specifically list those scenarios that you will allow a supplier to use as force majeure. Natural disasters, volcanoes, earthquakes. Yeah. You just want to make sure that they have a limited list, and you want to make sure that they have an obligation to try and minimize or help you minimize the disruption that you may face if they're affected by force majeure. And then on the other side, if you're as the client of the supplier, you want to make sure you protect the possibility that a force majeure event may interrupt your ability to pay the supplier, and put in there the possibility for you to argue that if you miss a payment or you're unable to pay a full amount due to the force majeure event, whether it causes you economic hardship or whatever, that you have the ability to then approach the supplier and renegotiate payment terms, renegotiate into installments, or at the very least excuse you from a possible default in payment due to that event. Sure. And it's very important to go and make sure that there is a force majeure clause in there, and that it is favorable.
Yeah. To you. Absolutely. And I think a lot of the lessons that come from that is being self-aware. Being self-aware as a business, when you're entering into the contract, are you going to be the party that's more likely to invoke the force majeure clause? Are you the party that's more likely to have to face against a party that's going to try to invoke the force majeure clause? And all of that is about self-awareness, because every time that you as a business sign up to a contract, you're signing up to certain rights and certain obligations, and it's important to be aware of your situation within that contractual arrangement. What is most likely going to happen? What are the scenarios that are going to play out?
Yeah.
And so I think a lot of your advice basically is around knowing that early on. Mm-hmm. How is this clause going to be used against me? How am I going to use it as leverage later on? And while we've been going through the COVID crisis, I've noticed many clients obviously trying to use either one side or the other, as you mentioned, of those clauses. And there's a lot of value when you said about characterizing your position, right? Sure. Documenting it, because and this is where if you're empowered enough, you may not even need a lawyer to do this. Mm-hmm. But the idea is to really start documenting and understanding and looking at your particular invocation of the force majeure clause, with painting it that it's impossible for me to perform, yeah. Right? And building out and creating that documentary record that eventually might have to go to court. you might have to go to court and defend your position and why you're invoking one position or the other on the first.
We are a business and we weren't immune to this. I remember in mid-March, what we did was, as soon as we realized that this could be an issue, we got on the phone to all of our clients and started to make them understand that, make them understand what force majeure arguments they can and cannot make, and that we understand this, and we started discussing with our clients the real hardships that we would face if they weren't if we didn't continue to have a relationship. We got on the phone right away to make them understand, to make it personal, to make them understand that we're important to their existence. And we started discussing with our clients renegotiations on payment terms, discounts, etc., in order to create a dialogue so that we're not suddenly surprised when they don't pay us. And we've already dealt with all of this stuff. So there is the contractual side, but there's also the relationship side. You are in business, and businesses, doing business on a regular basis and thinking long term. You need to build a relationship with your suppliers and clients, and they want to have that relationship with you. So if you see this coming down the road, don't just suddenly turn contractual. Pick up the phone and speak to these human beings and try and figure out how together you will navigate this catastrophe, and you'd be surprised. People want to do the right thing.
Absolutely. And obviously, invoking force majeure is you have to make sure that you're not triggering any unwanted consequences. Because also recognize that some force majeure clauses, when you invoke force majeure, one, you should follow the notice provisions within that force majeure clause. It's highly important because it's a very formalistic clause to go through, and it will be looked at by the courts, and how you actually triggered the clause and whether it was in alignment with the contract. But also recognize that there are unwanted consequences potentially that come out of invoking a force majeure clause, because a force majeure clause may include consequences of suspension of the contract, which may be fine, but then it may also trigger termination. Many force majeure clauses do have that in there. And so I think that there was an element of herd mentality around the time of the COVID crisis, an almost automatic gut reaction that let's trigger force majeure, and without fully thinking through what kind of damage that might do to relationships, and also to potential contractual advantages that were in the contract in the first place. Mm-hmm. So again, I think the lesson here is about being self-aware. And any good lawyer worth their salt, their job is to help you be more self-aware, and they also become aware of your business. And the idea is for them to fully understand your business in order to better protect you. So it's really important to have that sense of awareness around these provisions.
And what was your biggest learning with the clients?
Yeah, I mean, I would say that the crisis for me, it brought up certain lessons in having to go back into documents that we didn't think we'd have to go back into for a lot of companies. One of the big lessons that we've had, a lot of the requests that we've had, is that in a situation where there's less revenue coming into the company, and potentially not knowing how long the company has to be living in this new world of a COVID crisis. So, around March, when the crisis hit, a lot of companies saw, okay, there's a pandemic here. We're in an unprecedented time. Not a lot of data was out there or information was out there about how long this period would last. And so I had many clients who were calling and basically saying, okay, we're potentially facing a disruption that might go up to 2021. There was some literature and some news articles that came around that said that, listen, a full recovery is not going to happen until 2022. So you have businesses which, are brick and mortar businesses, some other businesses which, potentially are completely impacted by the government rules, entertainment centers, things like that.
So these are disruptions to operations.
Disruptions to operations, exactly.
And that resulted in a need to go back into agreements to renegotiate the agreement.
So
which types of agreements?
So, for example, shareholder agreements. So I'll give one practical example is a company that has its operating mission. It has its licensed activity. It's doing what it's supposed to do, and all of a sudden the crisis hits, and all of a sudden that existing business activity doesn't make sense for the next 6 to 12 months.
Like what do you remember are you able to talk about the industry?
I think if I talk about the industry, it's a rather large player, so it may bring it up. It may identify them. Okay. So I'll hold back. Well, I can talk about one relatively easy one which was based on, say, healthcare. All of a sudden, the pivot moves to seeing where the demand is. It's a healthcare startup, and all of a sudden, there's a need for it's difficult to get to doctors and hospitals, right? So all of a sudden you're seeing an increased demand for doctors on demand, things like that.
Okay.
And so you see potential changes and pivots within the business model of the company to try to address market demand. Now,
that must have implications on whether they're working within their permitted
licensed activities. Yeah, exactly. And so it brings up a number of things, because now when you're starting to pivot away from your core agreed model, you're talking about, okay, the way the company is set up is it's set up to do these kinds of activities. And now I need to get a new license. I need to understand my regulatory position if I conduct this activity. And the other big part of it is it may not be just one founder. It may be a founder with a couple of co-founders, maybe a few investors, early stage investors who come in. They may have signed investment terms that say we have the right to, you need to get our approval if you're going to change business lines. All of a sudden that has a knock-on effect. And all of a sudden we've had to go back into shareholder agreements, which are, fundamentally important documents for any company. And to go back in and understand, okay, what happens if this changes? Do we, what are the corporate governance procedures we have to follow? Is it a board decision first, which then goes to the shareholders for a final approval? And, how do we basically reassess this company's strategy in line with the market? I see that there's a question that's come up. So this is touching upon the force majeure clause. So if there is no force majeure clause, can you still make a case of force majeure from a client perspective?
Yeah, what you'd need to do in that scenario. So if we're talking about a business relationship that's in the UAE or is governed by a contract that has UAE laws as the governing law, then yes, because the UAE Civil Code, which is the governing law for all relationships in the UAE, contains provisions that would allow for arguments based in the concepts of force majeure. Off the top of my head, there are 3 clauses. One deals with an unforeseeable event that causes a party to be unable to perform the contract, and that event should have not been foreseeable. If all those boxes are ticked, you can then argue to terminate the contract. Another clause under the Civil Code deals with scenarios where an event, again, unforeseeable, etc., makes it economically difficult to perform a contract, causes economic hardships, or is oppressive from an economic perspective to continue to perform the contract. And the civil code allows the parties to then renegotiate and make that contract fairer. Now the civil code requires an application to the Dubai courts, have a judge then try and make the contract more fair, to balance the liabilities and the obligations under the contract. But you can definitely cite that, practically you can cite that clause, and then try and do it yourself. There's also a clause in the civil code that deals with real estate specific issues.
Yeah, and that's that touches upon a point that another learning that I had during the crisis, which is around the dispute resolution clause. Again, this is just like the force majeure clause, pushed back to the end of the contract. Many startups don't pay full enough attention to this clause. It's probably one of the more important clauses to focus on, and the reason it's the fact that it's back in the contract is really unhelpful, because everyone loses patience by the time they get to the back of the contract, and they kind of just give up on the.
Patience is lost after the payment terms. Exactly,
and it shouldn't be. I mean, the dispute resolution is inextricably linked with payment and the payment risk and all of that, right? And it touches upon the force majeure clause that one of our guests has just touched upon. Look, the dispute resolution clause is such a fundamental part of the contract. It has huge consequences, and it's such an easy fix for any company to incorporate lessons and make sure that clause is drafted correctly. It's just quite simple. Whatever you write in the dispute resolution clause, which is the governing law, the law that will govern the contract. And number two, how will disputes be handled? Now, those two elements you have control of when you're drafting the contract to put them anywhere in the world, right? And so if you're in a situation where I'll give you an example. Many of our clients are, on the basis of the contract, they need to get paid. If they've provided certain services, if they've provided certain products, they need to get paid for it. Now, I've seen contracts written by two Dubai parties, and I've seen it come across our desk, where it basically says, disputes will be handled in the courts of England under English law. None of these two parties have they don't touch anywhere in England. None of their activities touch in England. There is nothing that links them to England. And so what you're talking about is a situation here where, say you're a company that's owed 100,000 dirhams, you will now, under that contract, be locked into, potentially, if it says, the exclusive jurisdiction of the English courts, you're locked into going and arguing in England to try to get a judgment against the other party, and then try to secure that judgment, and then try to bring that judgment here in Dubai where the other party's assets sit. And it's completely inefficient, and it basically means you're not going to be able to practically enforce that contract, because the cost of going and doing that proceeding with that dispute is going to be prohibitively expensive. So you're not actually going to be able to enforce the contract is not really worth much, because you're not able to actually enforce it. And so that's why it's such a fundamentally important clause in the contract. I'll give you another example, and this is a common mistake. In the dispute resolution clause that we've had to look at many in the last 3 to 4 months, because potential disputes are starting to come to the surface because we're in a time of stress. Everyone is trying to understand, okay, what are my remedies here? What am I exposed to? Or how can I use this contract against the other side? All of a sudden, all of this is coming to the table now. And I've seen contracts that have said things like, disputes under this contract will go to arbitration in Paris with a panel of 3 arbitrators using the governing law of England. These are 2 small companies. an arbitration in Paris under the ICC is going to cost upwards of $100,000 to run with, even if it's a simple, case. So it's completely impractical to use that dispute resolution procedure.
So, what would be the lesson learned from all of these dispute resolution clauses that you've seen that were just not drafted, with consideration? How would
Sure.
how would you go about it?
Yeah. So when you're looking at the dispute resolution clause, you're thinking about how am I going to enforce it and how am I going to be enforced against it. And so it's really, while it tends to be fact specific, and we might give different advice based on where the other counterparty is sitting, where you're sitting, on how to actually draft that clause. Because arbitration is good in certain situations. If you're dealing with a counterparty in another country, arbitration is great because you can use that arbitration award and apply it anywhere in the world under the New York Convention to the New York Convention countries. And so it's a very easily transportable judgment anywhere in the world. But
So if you're a startup, right, and you're starting out, what do you have from the experience that you've had over the last few months? Would you, as a startup, pick arbitration or courts? And how would a startup decide between both?
Sure. So if I'm a startup that is, for example, providing services or providing product to a company which is sitting outside of the UAE, and say they're sitting in, say Mexico or Spain. Let's just say Spain for the. It's important for me not to put my dispute resolution clause in Dubai courts, because if I get a judgment in Dubai courts, it will be difficult for me to enforce that Dubai court's judgment in Spain.
Okay.
Because Spanish courts are not going to be very, it'll just be a huge barrier to entry to actually running that case in Spain to enforce against that Spanish company. Because that Spanish company may not have assets in Dubai. And so what I typically recommend for a startup in that position is go with arbitration, go with expedited rules under an arbitration procedure, say like ICC. If you know that this contract may be enforced, that you may want to enforce it, you enforce it in Dubai, say for example, at Dubai International Arbitration Center. That way you can secure your arbitration award locally. You don't have to go anywhere else. You enforce it locally, and then you get your award locally. And then you can take that award quite simply to a Spanish lawyer who will be able to do a quicker enforcement in Spain against that company. But the biggest proportion of contractual arrangements are usually, for a lot of our sort of guests here from the Astrolabs community, for example, they're Dubai to Dubai companies, or maybe Dubai to GCC companies. In that situation, I highly recommend, if it's a low value contract and you are going to want to secure, say, 25 to 50,000 dirhams, worth of, even up to 200,000 dirhams worth of value, put in DIFC courts, small claims tribunal. Try to use the sort of the low value, easy, dispute resolution processes that are available locally in Dubai. With a DIFC SCT, for example, you don't need a lawyer to go and represent you in the first instance. And you can try to do everything on sort of a low cost way to enforce all these provisions that are in your contract, right? And if it's sort of higher value, higher value contracts, we tend to suggest DIFC courts just because they follow a precedent. They follow precedent and they follow a system of binding precedent on cases. Of course, if you go into Dubai courts, you are faced with a situation where the courts do not follow binding precedent. So you're a little bit in a situation where you're not sure, even if you have a strong contractual position, you're not completely sure based on the judge's application of the law and the involvement of experts. You're not really completely sure where that's going to go. So we tend to favor, if you know you want to enforce your contract and you want to increase your level of enforcement, try to include DIFC courts. That's sort of the rule of thumb. But of course, it's I give a massive disclaimer. The dispute resolution clause needs to be drafted correctly and appropriately, given your situation as a business and the other side, the other company that's involved. And if anything has shown me, one of the big lessons in COVID is that clause is deeply important, because if that clause is not drafted well, the contract is practically not going to be enforced, because you're just not going to want to go to this expense of going through a lengthy court or dispute resolution procedure, which is just going to cost you more money in a situation where everyone is suffering economically. You do not want to throw money into a lawsuit which you have no idea you're going to win.
Yeah. So we've talked about force majeure. We've talked about dispute resolution. You touched upon shareholder agreement issues. Did you want to say anything else on the friction that could happen between founders as a result of a force majeure type event?
Yeah, definitely in a liquidity crisis, as has happened from the COVID crisis. Clearly, there are,
I think one of probably the most important things is to make sure that you have an agreement between the founders that you can turn to when there is an event like this. It really puts a spotlight on the need to have a contract between the founders, which acts as a judge, an arbiter. You can turn to it and say, this is what we've agreed, how we're going to be doing the decision making, and then you can work from there to adjust to this pandemic. But it definitely must put a spotlight on the need for an agreement between the founders.
Absolutely. Without that agreement between the founders, you're operating in a vacuum. The founders are in a situation where the business is facing some serious issues. And if you have typically comprehensive shareholder agreements cover these kinds of situations. They allow for a clear methodology, a clear sequence of events that happens in order to get to a decision.
Sure.
It gives you a roadmap. It tells you, okay, so then gets taken up to the board level. It gets discussed. We may have a list of certain reserve matters for the board to decide on. Then it perhaps then goes to the shareholders if that's how it's structured. But there's a roadmap to follow in assessing how to make decisions for the company. Because when you're in a situation like this where everything's constricted and money's not coming in and everyone is stressed, the chance of disputes between founders is highly pervasive. Yeah. It's very possible that the breakdowns of relationships happen by not setting out clearly the responsibilities, the roles, the sequence of events that should follow when a situation like this does happen.
Yeah.
So definitely shareholder agreements are absolutely vital.
And would you say it's better to have something rather than nothing? So even if it's just the main points, decision making, contributions, what each founder will contribute, how to share in any revenues, what would happen if additional funding is needed.
Exactly.
Anything else?
A
good dispute resolution clause.
Absolutely, a good dispute resolution clause.
Force majeure clause.
Perhaps even a mediation clause in between to allow for some room, because obviously between founders, these are relationships that you need to deal with very sensitively, because in a time like this, you need to have a way, a valve to allow the founders to come to an agreement. If you don't have a shareholders agreement in place, you typically just have the articles of association of the company, which, especially in this part of the world, the articles of association are very bare. They don't include much detail on how decisions are made. And so
I guess that the reason why that could be is because these are form templates put out by a specific authority that you've been incorporated under, that then you could then go to the company's law.
Exactly.
That is applicable under the governance of that authority, to look for how issues will be resolved, like decision making and so on. But if you have to go to the law to understand these things, and it's not just set out in front of you in a document, it can get pretty complicated.
No, absolutely.
And then you'll get into trying to understand and interpret legislation in order to resolve disputes, which is not an easy thing to do.
No, that's absolutely true. And founders, shareholders, these are very close and intimate relationships, and almost like getting into a marriage. And even when you bring in outside investors into the equity, you're bringing them very, very close to the way that the company is run. And so all of those terms that you brought these investors in on, all of a sudden in a situation like what we're facing with COVID, all of them take on a whole new level of importance. For example, many investors manage, and I'll just preface this with, anytime an investor comes into a business like a startup, they're negotiating on two things, economics and control. And every term sheet, every convertible note, safe agreement, every investment document tends to have provisions that fall into one or two, in one of the two categories. And so in a situation like where we are now, you're having investors who are much more picky, and they're going to be going through the economics and control provisions in those term sheets with a much more of an eagle eye, and they'll be trying to secure more economic benefits for themselves. Say, for example, liquidation preferences, the idea that they should be eating out of the pie earlier because of the risks that they're taking. And plus the value of their funds are now highly valued in the market with a liquidity crunch. And so,
and that you make the point that you're making. At least I want to pause on it for a second. Is that as a startup that requires fund that's in the process of fundraising, one should expect that in a scenario where there's an event like this, the stronger party becomes even more the party that has the cash to invest. And if you're doing fundraising round during, or you're thinking of doing a fundraising round during a pandemic, you're going to have to be giving up a lot of control.
Exactly. You're going to have to be highly aware of what the battleground is, because the investors are going to ask for things like, extensive reserve matter lists. Reserve matters are basically, appended to a shareholder agreement or articles of association, saying that, anytime you want to make these decisions, you're going to have to come back to me, the investor, before you can make those decisions. What that does, it kind of straitjackets the founders. If you don't get that balance right, you're potentially giving up control of a number of decisions where you're going to have to keep going back to the shareholder to get approval.
Is there a way to protect against that in advance, to at least give yourself a chance to be able to push back against the investor?
Yeah. So I tend to suggest to startups to understand their industry and the market practice in their industry, understand where the sort of the allocation of economics and control tends to happen in their industry, and use that as a starting point, and then demonstrate why their particular company may not have to, should not have to give up that level of control. There are arguments that can be built out, especially with experienced startup founders who've done these investment rounds, or many investment rounds, maybe in different companies. They are highly aware of that delicate balance between the control provisions that they have to give up. But if you're a founder who's not had to go through those, an experienced startup lawyer can guide them on understanding, okay, listen, this is something that the investors, what they're asking is completely inappropriate for the market. That's one argument to use, is that there is a market standard, and this is you can even use market standards from as far away as Silicon Valley, arguing that, listen, we don't have a precedent, a custom here in this region, but we do have data points from other parts of the world, and so we can kind of say, okay, listen, the breakdown of economics and control should be this way. And then there are other ways in which to, obviously there are moving front lines in the term sheet, the investor term sheet. And so if you are going to give up certain control provisions, then obviously you're going to, perhaps have new arguments to argue against liquidation preferences. And so you're able to basically say, your risk is less, your control is more. And so you're able to kind of reduce other parts of the term sheet and use it as a bargaining chip. And so it's just it's.
So that's what we were saying, essentially, good preparation. Understand if you're not an experienced founder, experienced in starting a lot of companies, seek out someone who has, and understand what the dynamics are in your industry, and prepare for prepare arguments that you can make in response to investors who are using their cash as leverage to get concessions out of you regarding control.
Exactly.
And one of those kind of clear, common sense argument for me would be that you want to leave control in the hands of the people who know the technology, who know the operations of the business, in order for it to be able to respond quickly. Because there's nothing worse for a startup than not being able to respond quickly to economic catastrophe.
Yeah, absolutely. I mean, it's another point also is that the investors or potential investors might, initially, maybe before COVID, were more interested in equity, and you're starting to see investors who are more interested now in debt, really, because they're, the way of thinking is that I'd rather sit, at the debt level where, if we're in a pretty major crisis, if the business doesn't survive, I want to be able to eat out of the liquidation proceeds as a debt holder rather than an equity holder. So you need to be aware that these are the mindset of the investor is deeply important to understand when you're negotiating these term sheets, because you need to understand where they're coming from and understand their psychology and why they're asking for certain things, and in order to prepare better to counter those arguments. But yeah, definitely that you're right. It's definitely a question of being prepared.
Yeah. Are there any questions? No. Please feel free to post questions, and we can answer them if you have any specific questions. We have another 30 minutes, during which we'd be very happy to take and answer specific questions. Otherwise, we'll continue to go through our list. So feel free to either post or put yourselves off mute and ask your question. So from some of the other points that we've had or learnings is the fundraising issues we've spoken about, operational pivots we've touched upon. Is there anything else?
I mean, I think another major issues that one of the other major issues that has come up is solvency related. So a company, say a founder is concerned. Obviously, startups are already operating in a very lean manner.
Also the solvency issues that arise out of startups committing too early to significant leases, significant employment obligations, that could lead to startup or even investments in technology too early that could lead to that.
Absolutely.
Insolvency
issue. Yeah, absolutely. And it may be for a number of reasons, as you said, that they've basically been burdened with these obligations, and they see the cash flow coming in, sort of starting to dry up. And you're in a position where you might project for 3 months, 6 months, 10 months that I have enough cash flow to get through. But this is where it gets tricky. Is where at which point are you potentially trading while insolvent? And that's an issue that is really important. It's deeply important because a founder, as a director, may end up being personally liable under the statutory law if they're technically trading while insolvent. And so it's very, and there are tests under, for example, the UAE law, which test whether there's enough cash flow to cover the expenses of the business. You have to decide at what point and in what manner do I bring up this insolvency issue through our corporate governance or our company. Do we bring it at the board, then discuss it at the shareholder level, request debt funding from third-party sources. What is the waterfall? Do I go back to the shareholders and ask them to contribute? Do you have the ability to dilute certain shareholders if they don't contribute their funds? Or certain investors, do they have anti-dilution clauses? All of this now comes into play because all of a sudden now you're in a situation where the company is on a knife edge potentially, and you have to evaluate and strategize. How do I get the company away from this red zone, this danger zone, where potentially, because in most situations, you've set up a company and it has limited liability features which allow you not to be personally liable, but all of a sudden when you're sitting in this danger zone where the company is facing serious insolvency issues, and if they do fall within the tests of the statutory law, the director, the founder, the persons actually conducting business with the company are potentially trading while insolvent, creating potential personal liability. And so this crisis has brought that very much to the forefront, and most founders need to be aware of their solvency position, due diligence on where the company is financially.
I mean, if you think about it, our generation has really had a comfortable business environment for decades now. This is really the first time that anything this significant. I mean, you think about it, world wars, we've been quite comfortable. This is the first time there's been a global crisis of this extent, and it reminds you that you have to prepare for the worst. I mean, as a business, we consistently worked within our means, which has allowed us to hobble through, make it through. What's interesting and maybe positive is that even such a significant event, significant crisis, I think one's safe to prepare for operational disruptions and things. It would be safe to say 6 to 9 months of things could get really, really bad, and this is a good reminder that one should have that baked into the business plan.
Absolutely. It's
and not work so close to the bone.
Exactly. I mean,
grow slow.
Yeah. And it's completely unexpected. I mean, these are these unexpected events that have massive repercussions. You're right. I mean, before maybe a certain event might disrupt a certain industry, or it might disrupt a certain country. But we're talking about an event which actually disrupts, almost everybody. I mean, there are a handful of industries that have actually benefited from the COVID crisis, of course. I mean, that all being said, yes, but we've never seen such a massive detrimental hit to the rest of the businesses. So the businesses that have benefited are really in a small minority. So being in this posture of a debt, being in detriment, being detrimentally affected, this is the first time it's hit so many at the same time. And so that's why a lot of the work that we as lawyers do has ended up being stress testing all of these documents that we've drafted for our clients over all these years, and it stress tests these agreements, and honestly, it shows why well-drafted agreements are absolutely vital, because in the end, like I said, every contract is an allocation of risk. And so, when a situation like this happens, which is completely, unprecedented, who is going to take on the burden of that risk? Mm-hmm. And if it's properly thought through, and some of the contracts, that we've worked on have adequately, very well, actually, anticipated situations like this, or at least not situations like this, but have anticipated what would happen if an unexpected event does happen. And it places the risk on the appropriate party. And so, that's the same principle that applies, like I said, from a startup with, one founder and a couple of employees, all the way to every single, sort of large client that we have. It's really important to be self-aware in every contract about where you sit. Are you going to be the one who's going to be enforcing that contract? Are your obligations just payment obligations? Or are you having to actually perform certain tasks and certain services? And all of that to say that this is the time when you're stress testing all these agreements.
Yeah.
And you see all the warts, and you see all of the issues in these documents. You finally see them all come up to the surface, and we're dealing with them now.
Yeah. Okay. Any questions? Well, we've been now on for an hour. I think if there are any questions that anyone would like to ask, please put them on the chat. I think we've covered pretty much everything that we wanted to. So if there aren't any questions, then we'll bring this to a close. Let's give a second to the guests.
Thank you, Ayman. It was great having you.
Okay. Any last words? Oh, thank you.
Thanks.
Thank you. Bye-bye.
Take care, everyone.
Bye-bye.